It's not an uncontested divorce if you haven't figured out child custody. And by child custody, I mean parenting time, the time that the child or children spend with each of you, and also how decisions are made. After all, this is one of the most important things that a court has to decide. And if you haven't figured it out and wrote it down so that the court can have a court order, your divorce is not uncontested. When I see parents DIY a parenting plan, I see them leave out a lot of details. There are so many things to think about, and if you're getting along, it's really easy to say, oh, well, we'll just agree to spend holidays together, or oh, we'll always celebrate the child's birthday together. But that doesn't take into account what happens if one or both of you gets remarried, or what if one or both of you moves far away, or your children that are 2 and 5 now, they're someday going to be 16, 17, 18. What if you don't agree on when they can get a driver's license? Or what if that 16-year-old doesn't want to go back and forth between mom's house and dad's house every other week? Or what if the child that has primarily lived with mom wants a chance to see what it's like to live primarily with dad? And thinking through these things, and I'm not saying that you can make a parenting plan that's going to survive your child, into adulthood, but you can think about mechanisms for, hey, these are some times we're going to look at it and see if a change is needed, and here's how we're going to make the change. You also want to think about things like, do you have to agree on babysitters, or do each of you trust the other one to choose an appropriate babysitter? Maybe you think right now that you each decide that they can choose a babysitter on their own, but what happens when one or both of you starts dating someone else and using that person as a babysitter? Is that okay with you? Is that okay with them? Have you talked about it? What about discipline? How's discipline going to be done in both households? What about bedtime? What about what foods they eat? What about what schools they attend? What about what extracurricular activities? What about if I go away overnight and it's my time with the kids? Can I use anybody to watch the kids? Or do I have to give right of first refusal to the other parent? I'm not trying to scare you. There are 50 million things, but this is why you work with attorneys who have done this for a very long time. Some of the worst parenting plans I've seen are done in 2 different ways. The one is DIY, where people just don't put in enough detail. And another one are mediated agreements that are not mediated by quality family law attorneys, but by other people who leave things nebulous and not detailed. And just remember, your parenting plan, it's the default. It's the backup plan. So if the 2 of you can't agree, you have something written down. But it doesn't mean that if the 2 of you agree, hey, on Christmas Eve, pickup is going to be at 3 instead of at 12, that you can't just agree to change it, or at least change it for that year. But you got to have a default and you got to have details. You don't have an uncontested divorce if you haven't resolved child support. And I will tell you, this one has come back to bite some people in the butt because they'll just agree, hey, you're with the child this amount of time, you're with the child this amount of time, and each of us will take care of the child when the child's with us. We won't do child support. No, that's not how this works. The state of Maryland has recently come out with a case, and they're not going to let that happen. They're going to make sure that child support is at the very least considered, that you have put your incomes in, that the child support guidelines, if appropriate, have been applied, and to make sure that that support is paid because it is owed to the child, not between the 2 of you. There was recently a case where parents agreed, hey, each of us are going to be responsible for the kids and I'm going to pay this expense, they're going to pay that expense, and it's going to be fine. And the court said, no, our job is to look out for the best interest of your child. And because of that, we're going to take testimony, whether you want to or not, and we're going to take testimony about your incomes, and we're going to order child support according to the child support guidelines. And that was upheld. So like it or not, Maryland has laws about child support, and you got to follow it. You don't have an uncontested divorce if you haven't dealt with the issue of alimony. And dealing with the issue of alimony might mean that both of you waive your right to receive alimony from the other. Or it might be that somebody's getting some rehabilitative alimony so they can go back to school or get back out in the workforce. Or it might mean that one of you is agreeing to support the other one for the long term. It doesn't really matter what your agreement is. What matters is that you have to have one and that your agreement has to state what it is, because that's one of the issues that the court is required to decide. So maybe you'll agree to waive it, maybe you'll agree to some short-term alimony, maybe it'll be long-term alimony, but you got to deal with it, because if you don't, your divorce isn't done. You don't have an uncontested divorce unless your agreement is written down and signed. That's right. It has to be written down and signed. Don't call a law firm and say, my divorce is uncontested. Oh, great. Where's your agreement? Oh, we've just verbally agreed. Guys, we've heard it all the time. I know you think it's uncontested, but it's just not. It's not uncontested, and you can't file it as an uncontested divorce until all the issues are written down and it is signed. And hopefully that is where you're going. If you think you've resolved all the issues, hopefully that is exactly where you're going to go. But so many times we have seen these agreements fall apart because, as the saying goes, the devil's in the details. And once you start writing out the details of how things are going to happen, people get scared, or people realize they didn't really have a meeting of the minds, or they're not actually on the same page. They just believed that they were. It's contested until the marital settlement agreement, until the agreement between the two of you is actually signed. And then you can file for that uncontested divorce and move on to your new beginning. If you think you have an uncontested divorce, make sure that you have considered all of the things. Make sure that you have a child custody agreement. Make sure that you have an agreement on child support, on alimony, on property division, and make sure everything has been written down and signed. If you've done all that, you've checked all the boxes, congratulations, you have an uncontested divorce. But if you still have some boxes to check, we're here to help. Divorce doesn't have to be messy, and it doesn't have to be a big fight. And it doesn't always have to lead to a big court battle, and hiring lawyers doesn't mean that you're not handling things peacefully, respectfully, and responsibly. It just means that you're hiring a helping hand, someone to guide you through to your new beginning. At Z Family Law, we don't write endings, we create new beginnings, and we're here to help you create yours.